Mr. Chairman. Mr. Chairman, I took a point of order, Mr. Chairman.
Point of order, the Honourable Member Charles Chauvel.
Sir, I took a point of order when Mr. Roy was in the chair because he asked Asanati Lawley-Taylor to stop speaking when she started to address the issue of the Minister's supplementary order paper. Now, I believe that was an error on the former Chairman's part. I think he acknowledged that probably to you and to the Minister before he left, because the fact is that the Minister's SOP substantially amends Part 1. He did mention the new Part 3, but that's a very, very small part dealing with consequential amendments to the Smoke-Free Environments Act. So, Sir, could you just clarify that my understanding is correct and that it is in order to refer to the Minister's supplementary order paper, because that's what I want to do, and I think others will want to do that as well.
Yes, that's the understanding. I call the Honourable Member Charles Chauvel.
Mr. Chairman, I just want to deal with this supplementary order paper number 171. Before I do, though, I do want to address two comments that the Minister made when she was on her feet. First of all, I asked early on in this committee stage whether certain safeguards that apply to public sector employment, certain ethical requirements that apply to public servants, would apply to private sector employees to whom public powers were delegated under the clause that is contemplating that delegation in Part 1. And the Minister got up and she reassured us about the contents of Section 119 of the Corrections Act. She didn't mention two particular documents that I wanted her to reassure the committee about, and I accept that she wasn't physically present when I asked these questions, but nonetheless she rose to the occasion and purported to answer my questions. I do want her to consider this issue. There are two fundamentally important ethical requirements that apply to public servants. One is the Public Service Code of Conduct, promulgated by the State Services Commissioner, made under the State Sector Act 1988. The other is the Departmental Code of Conduct, applying to all employees of the Department of Corrections. These are the fundamental documents that govern the day-to-day ethical behaviour of corrections officers, and I cannot see where the requirement to honour either of those documents is put upon private sector employees who exercise delegated authority from the Chief Executive. So it's all very well for the Minister to point to Section 119, which we can all read and have read. We all know that the Bill of Rights applies. We all know that the Ombudsman's Act applies. What about the Public Service Code of Conduct, Minister? And what about the Departmental Code of Conduct? That's the issue that I was fundamentally addressing to you, and I would like you to get your officials to tell you whether or not those documents apply, because if they don't, we have a problem. We have a fundamental problem because the employees of Serco and the employees of other private entities who might receive delegations of public authority from the Chief Executive of the Department of Corrections won't have the same fundamental ethical requirements that do apply to public servants. And because of the reasons that were articulated by Ian Lees-Galloway, who's just resumed his seat, because this is the fundamental business of administering our prisons, dealing with people who have been deprived of their liberty by the state, those ethical obligations must apply. If they do not, this is an obscene exercise and it should not proceed. Now, Sir, the other point I want to make before I address the SOP directly is a comment that the Minister made before she resumed her seat. She said she invited me to give her my ideas on the Department of Corrections and how we might do things better. Sir, the fact is, this is what the Minister did, and she should know this because I acknowledged her consultation over the SOP in my speech yesterday on the second reading. She did tell me that she had a supplementary order paper she wanted to propose. She consulted me about it, and she showed me the SOP in draft. And I acknowledge that that was the proper thing for her to do. She also said to me in passing, when I said to her that we would have difficulty supporting the legislation generally because of the privatisation provision and because of the strip searching provisions, that the Māori Party weren't going to be supporting the strip searching provisions either. So if we had any ideas on strip searching to make that particular part of the bill better, I was welcome to give them to her. Well, I think our views are known. There shouldn't be the standardisation in favour of the drastic procedure. It's been said by a number of our speakers in the House already. I don't think that I've been invited by the Minister to be forthcoming with ideas above and beyond that, and I certainly, if I was so invited, would be inundating her with suggestions. But, Sir, back to this supplementary order paper number 171. Here's the problem. A number of years ago, Judith Collins, when she was the Minister, decided that prisons would be smoke-free. We thought that was a good idea, and it has been a good idea in practice. But it was implemented the wrong way. What the Minister thought, the previous Minister, was that she could get away with instructing every manager in every prison to simultaneously declare tobacco to be a contraband good, and then to put in place prison-by-prison rules as to disciplining prisoners who used tobacco. Now, Mr Chairman.
Charles Chauvel.
Thank you, sir. We said at the time that was brave. And in fact, it was worse than brave, it was reckless. And we've seen this sort of reckless behaviour from Judith Collins in the discharge of the Justice portfolio time and time again. What should have happened is legislation should have come to this House. It should have gone to a select committee for public submission, should have gone through the checks and balances, and then it could have been made law. And there would have been no doubt about the legality of the smoking ban. As it is, a well-known activist inmate at Auckland Maximum Security Prison went to the High Court, and earlier this year he got a decision from the High Court confirming that the manner in which Judith Collins went off half-cocked in implementing this ban was legally wrong. Now, despite that, the Department has maintained the ban. I don't know on the basis of what legal authority, and I don't know on what basis the taxpayers' interests will be protected here, given the liability that's probably accrued to the Crown since. But leaving that issue aside, the Minister's brought this supplementary order paper to the House, which will confirm the basis of the ban, and it will also, interestingly, by way of clause 179AA2, extinguish any proceedings brought against the Crown questioning the validity of any rules or regulations that are referred to in the particular supplementary order paper. Now, Minister, you showed me this supplementary order paper as you undertook to do. I've read it, and I want to give you my response. I think it's the wrong way to go, and I think that for the following reason. What is the meaning of questioning the validity of any rules or regulations? Any proceeding questioning the validity of any rules or regulations? Does that apply to a Regulations Review Committee complaint? I don't think so. So immediately we've got one hole in the supplementary order paper, one means by which anyone could mount an attack on these rules and regulations independently of court proceedings, and probably will do so, given the litigiousness that is rife in the sector. But what about a proceeding for bagent damages or judicial review brought purely under the New Zealand Bill of Rights Act? For example, for the breach of Section 21, which prevents unreasonable search and seizure. Now, there's no doubt in my mind that if the supplementary order paper passes in its current form, the seizure or the searching for of tobacco contraband will be lawful. But will it be reasonable? And that question is not answered by the supplementary order paper, so there's another type of court proceeding that might still be open to inmates or others by which to question the ban because of the wording of the supplementary order paper. And what about a proceeding under Section 27.3 of the New Zealand Bill of Rights Act, which actually, in and of itself, confers and affirms a right to sue the Crown in civil proceedings? That wouldn't necessarily be a proceeding in and of itself to question the validity of any rules or regulations that are confirmed by the supplementary order paper. But it might still be a way by which somebody could attack the ban on the legality of the ban on tobacco products being present in prisons. Minister, the other problem I think you have is that we just don't know whether there are any proceedings extant at the moment. You might know, the department might know, the Crown Law Office might know. You might like to share that information with the committee, because if there are proceedings, then the committee should know how many there are, what the potential liability to the Crown is as a result of those proceedings, and whether or not by passing this supplementary order paper in its present form, we're simply in the process of selectively extinguishing some legal proceedings, but not others. I don't think that the committee or the House should be put into that position in a state of ignorance. They should be seized of the facts so that when legislating we know exactly what context we're dealing with. And sir, we just don't know that. We don't have that information. We simply have this SOP which would, as I say, prevent proceedings being brought against the Crown questioning the validity of any rules or regulations referred to. Now, sir, I think that's a very important point, and I do hope that the Minister will speak to this issue, because, as I say, while we are supportive of the ban, the way in which it's being achieved is poor.
I call the Honourable Member Ian McKelvey